Okay, this one is on land titles, and what we're going to be talking about is land now, okay? We're all products of the government's educational system. The government has taught us what we need to know to operate in their system, but have they taught us everything? There's several kinds of estates. There's absolute estate. An absolute estate is a full and complete estate, and a estate in lands not subject to be disputed upon any condition. Allodial means free, not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. What you see nowadays is feudal, but you can have allodial. Allodium, land held absolutely in one's own right and not of any lord or superior. Land not subject to feudal duties or burdens. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Now, I just want to get some documents here. I got some land patents back here, and I just like to this one somebody's been handing around. This is an example of a land patent. These are BLM. These are back. There's only a few of them, so you got to pass them around, take a look at them. What this is, I guess I'll turn this on first. What I have here is this is one of those railroad land grants, okay? And this is a Santa Fe Pacific Railroad Company land grant. When they built the railroads, they gave the railroads 10 miles of land on either side of the railroad, and that was to pay for the railroad, okay? And this is one of those land grants. And so you ought to pass it around, take a look at it, and we're going to be talking about it. If you register your land, well, and this is in Canada, in the US, you have a county recorder, and it's recording your land. If you register your land at land titles, you're essentially giving them your land. And in Canada, it's very much more feudal than it is here. Even the Canadian land patents are feudal. And they even know it because they put them in boxes. They know they don't have any authority. But here, it's much more proper, I guess, de jure. The land patents, it's a stronger history, actually, with land. Okay, but anyway, so let's keep going here. So in Canada, though, you need to record your land. You need to train your bureaucrats about land titles. And even with the county recorder, or once you give them, and this is the same with land titles in Canada, once you give them a document, it's recorded, okay? And if they give it back to you, remember you had that question about that? About if they give it back to you, then that's condemning a government document. That's exactly what it is, and that's a felony, okay? But if you're going to accuse them of felonies, you better have witnesses. And so what you need to do is build a case against them so that you have witnesses and you can accuse them of a felony. Okay, because if you give them a document and they say, I'm not going to record that and give it back to you, they just committed a felony. That's condemning a government document, because once you gave it to them, it's theirs, it's recorded. Okay, and that's why I always send it to them by registered mail, because now I got proof they got it, and if they send it back, then they committed a felony and I got proof they did that, and you know. Anyways, so you need to build a case against them. That's you know, again, it comes down to the burden's on us to build a case and get our public servants into line, right? Real property, land and everything that is attached to the land. Real estate. You notice how they call everything real estate? Words are everything, okay? Real estate is real property that you have an interest in, but you don't own it. Estate is the operative word, and estate is something you have an interest in, but you don't own, like your father's estate. Okay? You know, all of this stuff is very subtle, and unless you're really watching for it, you won't even catch it. There's land titles come in various forms. There's a general warranty deed, a special warranty deed, a sheriff's deed, a judicial deed, a quitclaim deed, and a land patent. And this is the same in Canada. A general warranty deed is one where the seller warrants the title to be free of all liens and encumbrances. A general warranty deed is generally what's received in order to get a mortgage, but before the bank will authorize the mortgage, and a general warranty deed is considered to be marketable title. Okay, there's a land terminology you should be aware of, marketable title. We're going to see some court cases about that. A special warranty deed is the deed where the seller will warrant the land to be free of all liens and encumbrances with some reservations, okay? And the reason there might be a reservation if it was subject to a foreclosure or tax sale, okay? And that clouds the title. And a special warranty deed, though, is considered to be marketable title. Sheriff's deed, the sheriff sells real property, but whenever the sheriff sells it, it's usually because of a foreclosure or tax sale or, you know, a court-ordered sale. Sheriff's deed is considered to be marketable title. A judicial deed is when a judge orders real property sold. A judicial deed is considered to be marketable title. A quitclaim deed. A quitclaim deed essentially says that the seller transfers his interest in a piece of property. Okay? Property sold because of a tax sale. I've seen property sold because of a tax sale being a quitclaim deed. A quitclaim deed can transfer title as effectively as a general warranty deed, but it also may transfer nothing. Okay? Now, have you ever heard of the Brooklyn Bridge being sold? Yeah. Okay, well, it's always by quitclaim deed. Okay, and it's actually owned by the state of New York, and so they've never sold it. But a quitclaim deed essentially says, I sell you my interest in this bridge. I may not have an interest, but whatever interest I have, I sell. Right? That's what a quitclaim deed says. Okay? So, a quitclaim deed, a deed of conveyance operating by way of release that is intended to pass any title, interest, or claim which the grantor may have in the premises. That's why with a tax sale, okay, they're selling you their interest in the property, their claim on the property. Color. Okay, now we're getting back to color, remember? Those definitions of color. An appearance, a semblance, a simulacrum is distinguished from that which is real. Colorable, that which is an appearance only, not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. Color of law, misuse of power possessed by virtue of state law, made possible only because wrongdoer is clothed with authority of state, is action taken under color of law. Get a load of this. These deeds include the ones as follows: a warranty deed, a quitclaim deed, a sheriff's deed, a trustee deed, a judicial deed, a tax deed, a will, or any other instrument that purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title. When we say a person has a color of title, whatever may be the meaning of the phrase, we express the idea that at least that act has been previously done by which some title, good or bad, to a parcel of land of definite extent has been conveyed to him. There the complainant seems to have relied upon the tax deed as conveying to him the fee, and to sustain such a bill it was incumbent upon him to show that all the requirements have been complied with. In other words, you know, I don't care about the fee. That's fee simple. That's in the matrix. That's immaterial to what the reason I'm bringing this out here, okay? The point is that when you buy the land, remember, caveat emptor, right? Buyer beware. If you buy land from somebody, it's up to you to prove you have title. Okay? You need to be aware of that. You buy land from somebody, they don't have to prove they sold you anything. You have to prove that you have title if you want that land. I mean, the guy could be involved in fraud, but that's a civil matter. You see what I'm saying? You have to prove you have title. Yes?
What kind of deed do you ask for if you want a deed that you don't want to record or to establish ownership?
We'll talk about that. Authorities hold that to render a title marketable is not only necessary that it shall be free from reasonable doubt. In other words, that a purchaser is not entitled to demand a title absolutely free from every possible suspicion. Okay, so they're saying essentially that marketable title does not necessarily mean that your title is free from all suspicions. Okay, marketable title is just reasonable doubt. Okay, it comes down to these vague words that they like using in the matrix. A patent to land issued by the United States under authority of the law is the highest evidence of title, something upon which its holder can rely for peace and security in his possession. It is conclusive evidence of title against the United States and all the world. Okay, so, excuse me, a land patent is the highest and best title. Okay, and that is the real title. But it's like Morpheus said, I'll show you how deep this rabbit hole goes. Okay, nothing but a patent passes a perfect and consummate title. Okay, a patent issued by the government of the United States is legal and conclusive evidence of title to the land described therein. No equitable interest, however strong, to land described in such a patent can prevail at law against the patent. Now remember that guy that went and did the bill of exchange on the vehicle, right? He said he was transferring his legal and equitable title. Okay? Now you have to understand, when we get into de jure government, everything's under martial law, and what happens is that the courts use their equitable powers. Okay? And what happens is that because the government's bankrupt, okay, equity, see, normally equity is supposed to follow common law. Okay? And equity is the power of the court to do what's right. Okay? And normally equity is supposed to follow common law, but under martial law, there is no common law. And so then what happens is equity can do anything they want. And in fact, in Canada, they actually codified it in some statutes, and they might even have done it here, where in the statutes in Canada, they will say that where equity and common law conflict, equity always prevails. Okay? Yeah. And so what they're saying, essentially, and so then what happens when the banks want to foreclose on your house, right? Then the court will basically ignore all your arguments and give the bank and just let them do whatever they want to do and make them so they don't have to produce the note, just let them do whatever they want to do because the government's bankrupt, there's no common law, and equity prevails. And equity allows them to do anything they want, basically. And that's what you see going on in the courts, is that they can do literally anything they want, and it's because that everything's in bankruptcy. Anyways, so the reason I mentioned that is the issue here is no equitable interest, however strong, to land described in such a patent can prevail at law against the patent. Okay? So no equitable interest. And that's powerful. That is really powerful. Anyways, a patent is the highest evidence of title and is conclusive against the government and all claiming under junior patents or titles until it is set aside or annulled by some judicial tribunal. Issuance of a government patent granting title to land is the most accredited type of conveyance known to our law. A patent is intended to quiet title to and secure the enjoyment of the land for the patentees and their successors. Thus, as a quitclaim deed, see that? As a quitclaim deed, a land patent conveys whatever interest the government has in the soil and the land. Now, the reason that's important is, think about it. Who was here first? Who was here first? Huh? The First Nations. Exactly. So the government essentially stole the land. That's what even the Canadian courts are saying, that the government has to settle the Indian land. The First Nations. Exactly. So the government essentially stole the land. That's what even the Canadian courts are saying, that the government has to settle the Indian land claims. And the reason is they're essentially saying the government stole the land in the first place. And so really, if you think about it, and this is why I'd like to get some de jure chiefs to sell me some BLM land, and I'd be willing to take it into court because I think I'd win.
So technically, from if I'm hearing you correctly, a de jure government like the Republic of Texas, if they've got all their ducks in a row with a land commissioner and this, that, and the other, then the Republic of Texas can issue land patents.
That's something worth interesting. The question was whether the Republic of Texas could issue land patents, especially on people that are having their house foreclosed on and stuff like that. And that's something that possible. I guess I hadn't really considered that. They could certainly tie it up, you know. But you know, the key is that you know, you need to put the mechanisms in place and do it a few times and see what happens. You know, it's like boiling a frog. You ever boiled a frog?
Right. Please don't give me that analogy again.
Well, it's okay.
Politicians have given it a bad name.
Yeah. Well, if you throw the frog in a pot of boiling water, he's going to jump out. But if you put it in there and turn it up, then what I'm saying is that the Republic of Texas should issue a land patent on somebody's land and see what happens. And especially some land that nobody cares about. Right. You see what I'm saying? And then what they do is they gradually turn up the heat. Maybe they issue a land patent on some land that some people care about, and then they issue a land patent, huh?
Like the Capitol building?
Well, that would be the last one. Yeah, that's what I wanted to do in Canada, is to have them issue me a land patent on the Parliament buildings after we do it in some other areas that are not as important. You know what I mean? Right. And then I'd send them a bill for rent, you know? There you go. Anyways, food for thought. As we have noted in connection with a patent by the United States, the patent's effect is the same as though the United States had executed a quitclaim deed. Again, you know, it's because it's a colorable title. You know, the highest and best title is a land patent, but really the highest and best title is a First Nations patent. Think about it. That's really powerful. A patent operates as a deed of the government. As a deed, its operation is that of a quitclaim. It passes only the title the government has on the date of the patent. A patent of the United States as a deed, its operation is that of a quitclaim, or rather of a conveyance of such interest as the United States possessed in the land. A land patent is the highest and best title, but at the same time it's a quitclaim deed. If a land patent is a callable title, then what would be true allodial title? There is nothing here requiring a deed to establish a color of title, and under former decisions of the court, color of title may exist without a deed. And that's true. Squatters' rights. Think about it. If you're on the land for 7 years, it's yours. That's why when you homestead, you know, you go and sit on the land for 7 years. I mean, they don't have any choice but to let you deed it over to you, because you basically homesteaded on the land for 7 years. That's the whole idea. Courts have ruled that the government has to settle the land claims of the original people. They're essentially saying the government stole their land. This is actually a Canadian land patent. You can see it's in a box. That tells me they don't have any authority. And if you read it, you know, the fine print at the bottom, they're talking about reserving, you know, all sorts of stuff. And where the U.S. patent, if you read those U.S. patents, they don't reserve anything. And I've got a Texas one. It's in my briefcase. I've got a Texas one, and you can actually, all you have to do is call up the Texas Land Commissioner. They have a website. There's an 800 number. Call up the Texas Lands Commissioner. Give them your survey number for your land, okay? And if it's not on your tax deed, you can call up the planning department for your city or county where you get your tax bill from, and they'll give you the survey number for your land, okay? And then all you have to do is call them up, have a credit card ready, tell them you want to talk to the historical department, and I think they charge like $5 to send you a certified copy of the original land patent on your property. And I'll show you one that I did where I brought forward the land patent on some land out in West Texas. And I'm in a little bit of a battle with them over it, because they sent me a bill for property taxes, but I think it'll be a slam dunk. Anyways, this is a U.S. land patent. This is one of those railroad land patents. This is actually the one that you pass around. Anyways, it says here, and granted by these presidents does given grant unto said Santa Fe Pacific Railroad Company to its heirs and assigns, or no, to its successors and assigns, the tracts of land listed as aforesaid and described to the foregoing, to have and sold said tracts with the appurtenances thereof unto them successor as aforesaid, and its successors and assigns forever. It doesn't have any restrictions. There's nothing. It's total and complete ownership of that land. But you know what they do is, and I think they did the same thing. Like if you go back to this one, okay, you'll see that it's the Calgary and Edmonton Land Company Limited, right? I'll bet you that's a Crown corporation, and I'll bet you this is exactly what they're doing here, because what happens is the railroad company then sells the land. Well, so how do they sell the land? They sell it with a callable title, right? So they have absolute title, but when they sell it, it's not absolute title anymore, unless the people are smart enough to know that they can bring forward all the rights and privileges of the land patent. You see what I'm saying? Otherwise, they have a callable title, which is really not a title. And here's the signature part. President of the United States having caused these letters patent. Now you got to understand, letters patent is just a letter from the government under official seal. That's it, nothing more. I can show you letters patents all day long. Anyways, a land patent is just another type of letters patent. Anyways, have caused the letters patent and the seal of the General Land Office affixed hereto, given under my hand, City of Washington, the 2nd day of December in the year 1915, and the 140th year of independence. And that's it. And there's no reservations at all on that. And recent land patents, if you know up at the, you saw the Crown patent that's in a box, that tells me they don't have any authority. They know they don't have any authority. Land granted to John Smith, his heirs and or assigns forever. All patents that I've seen always reserve something, all Crown ones. They reserve mineral rights, trees, water rights, something. I'll show you that Texas land patent. I'll go out and get it next time out of my car, out of my truck. But in the Texas land patent, it reserves mineral rights. But that's it, nothing else. Right. The land patents say nothing about property taxes, say nothing about easements, say nothing about eminent domain, say nothing about zoning rules and regulations, okay? So if you bring forward the land patent, you still have real close to absolute title, even if it does reserve mineral rights. Sometimes they reserve mineral rights. Other than mineral rights, there are no reservations in the U.S. And if you look at that one from Arizona, I think they reserved, I'd have to look at it. I think it might have said something about access for canals, irrigation stuff, you know, I'm not sure. Anyways, a usufruct, okay? A usufruct is a noun under Roman or civil law, the right of enjoyment of all the advantages derivable from the use of something that belongs to another, as far as is compatible with the substance of the thing not being destroyed or injured. A usufruct is a type of a trust, okay? And that's what's happening is, that's why they spell your name in all block capital letters, because it's not you, it's the trust. And what they're doing is they're charging you a fee to manage your trust. That's exactly what's going on.
I think sometimes in Texas this is called a life estate.
Well, that life estate is another type of estate.
Yeah.
Yeah, that's any law dictionary has life estates in it. That's just another type of estate. And so a usufruct is not a type of a life estate. A life estate is something that you get to use it for the rest of your life. And so that's not a usufruct. A usufruct, you get to use it and you can pass it on to your kids. And so it's not for life. It's, you know, and you pass it on for your family, and as long as everybody's paying the tribute. But again, if you want to have absolute ownership, you bring forward all the rights and privileges of the land patent and pay for it with coin, and make sure that that usufruct isn't set up. Then you'll have absolute ownership of the land. Federal Reserve notes. This says Bank of Canada notes. Federal Reserve notes are promissory notes. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States, the validity of which is solemnly established by the 14th Amendment. Okay? So then Federal Reserve notes are promissory notes, aren't they? They're commercial paper. When you pay for land with a bank note, it is not paid for, therefore a trust is created. That's why the government has eminent domain. The government stole the land. By paying for the land with commercial paper, you gave it back. Or the government sold the land, and then by paying for the land with commercial paper, you gave it back to them. Have you ever seen a road that goes along in a straight line until it comes to somebody's land and then goes around the land and then keeps on going straight. Well, that's because that guy had eminent domain. They didn't have eminent domain on that guy's land because he didn't have colorable title. There's people in Arizona that I know that have passed their land on in the family from generation to generation. They've held it in their land in the family for generations, and they do not pay property taxes. There's no record of it anywhere. And it's their land and they keep it and they pass it on from grandmother to son and just like that. And so there's Spanish land grants in Arizona, that huge tracts of land that were granted by the Spanish government back in what, the 1600s or the 1700s to these Spanish families before Spain was even separate, before when Arizona was part of Mexico. And before Mexico was separated from Spain, you know, they granted these huge tracts of land. Those Spanish land grants are still there. And if you have absolute ownership of your land, you just pass it on in your family, yes. Well, it's as long as it's not transferred, then it is free by definition. You see what I'm saying? I haven't seen the Spanish land grants, but I've seen the maps that have it all marked out. And yes.
I have a friend whose family is part of a Spanish land grant up around Las Vegas, New Mexico. And the state of New Mexico took a bunch of their land away from them a long time ago, and they just won a lawsuit getting that land back.
Right on. Right on. How did they, obviously they didn't have a shred of authority because the courts ruled against them, but I just can't believe that they even tried.
Well, they got their land back, I know that.
Yeah, he was talking about Spanish land grants in New Mexico and how the state of New Mexico stole the land and they just, there was a lawsuit and they lost the lawsuit. Anyways, okay, so, okay, we've already talked about this. Spanish land grants in Arizona. Evidence of your usufruct, okay? They call it real estate. You pay a yearly rent. They take it away from you. They can take it away from you with eminent domain, and if they can take it away from you, you don't own it. Your land has easements, utilities, roads, etc. Your land is subject to zoning rules and regulations. That's all evidence that you don't really own it. If you pay for land with a promissory note, it creates a trust. The way you defeat the trust is you have to pay for the land with gold or silver coin, and you have to say it in the deed because they can presume that you're using commercial paper. You know, most of these deeds say upon receipt of $10, and it's an S with one vertical bar, as, you know, upon receipt of $10 and other good and valuable consideration. Well, you know, obviously they can presume it's commercial paper. How can you have true allodial title to land? You bring forward all the rights and privileges of the land patent. You pay for your land with gold or silver coin. At common law, all numbers are spelled out. If you look at these land patents, the numbers are spelled out. It's F-I-V-E, not the number 5. The numbers 5 is an Arabic numeral in that even if you look in those executor documents, they're spelling out all the numbers, okay? That's common law. Legal description needs to be in metes and bounds, although I did, like if you look at that one I did in Arizona, I didn't do that in metes and bounds. And I hurt those people. Those people that stole my house, you know, they can't sell it. The title is clouded. And yes.
A quick question. What if you've got somebody who is from within their system has already quote unquote paid for it, but they're still being held hostage by the taxes? I mean, can you go back? I mean, can you go back and try and offer the taxes in gold and silver and make that for your claim? Or, I mean, what if somebody's already paid off the banknote, basically?
Well, actually, that's something that you might want to talk to Jerry about, because Jerry is actually dealing with them, and there's some stuff in Texas law about rendering and some other things, that they might want to look into. Another thing is that it's all commerce for sure. But again, there's they don't, in Texas especially, the what do they call it? There's terminology, the kind of taxes they do on property taxes. No, ad valorem taxes in Texas are unconstitutional anyways. But you know, the point is all you have to do is you can talk to Jerry. He could probably help you. But beyond that is do what I did with that land patent there. Okay, is you bring forward all the rights and privileges. You know what I did is transfer it from myself to myself, and when I transfer it back to myself, together with all the rights and privileges of the original land patent. Okay, or you can transfer it to someone else. You know, I'll set up a company, transfer it to the company, and then pay for it with gold or silver coin. I mean, use your imagination. There's lots of ways you can deal with it. Yes?
Just a quick question.
The number 5 is Arabic.
Arabic.
Well,
What do you mean,
so
define
when
that?
you say 5, you put down F-I-V-E instead of using the number 5.
Okay.
You
but I
put
mean,
down,
I'm just wondering why you're distinguishing 5 as Arabic, and they have other numerals too.
all of them are Arabic.
Yeah.
Either way, they're in the matrix, okay?
Well, actually, a triangle.
You know, whatever. It's all, you spell it out, okay?
All right.
If you look at these land patents, they're all spelled out, and you spell it out. You don't put in any Arabic numbers. But even with that, a patent from the original people would trump any other patent. Because almost everything is done these days with commercial paper. The courts presume that commercial paper was used. You have to, if you want to defeat their presumption, then you need to put it on the document what was received. And in fact, my last one, I got it in my briefcase, I'll show you. The last ones I did, I put on a bill of exchange and deed. I think I put a bill of exchange and deed. Because I wanted to make sure that it's an exchange. That's what it is if you think about it. Upon receipt of 20 each 1 tri-ounce pieces of silver, pure silver each, I do hereby grant in exchange to John Henry, House of Smith, this land together with all the rights and privileges, the original land patent number 123456, a true copy of which is attached hereto and incorporated herein by reference in its entirety. I mean, that's essentially what it would have to say, you know. When you get true allodial title, I'll bring my briefcase in, and I got a bunch of stuff in there that I can show you. When you get true allodial title, you do not tell them that you purchased your land. Okay, purchased is a commercial transaction, or bought the land is a commercial transaction. You can tell them you converted some silver or gold to land. That's fine. Conversion is common law. I've seen court cases that talk about it that way. Okay. The guy converted some silver to land. I've seen court cases that actually said that, those words. Well, when you're talking to somebody, I mean, unless they want to know the value, but is it any of their business? I mean, you know, really? None of your damn business. In this act, surrendered lands means a reserve or part of a reserve, or any interest therein, the legal title to which remains vested in Her Majesty, that has been released or surrendered by the band for whose use and benefit it was set apart. Yeah, isn't that's lawyers' verbiage, eh, how they twist it around. This is the Prize Act, and this is very similar to the Trading with the Enemy Act, okay? If you're a person, you're an enemy of the state. And this is the Prize Act in Canada, and so, if you go down here, it says here, where it says persons underlined, okay? The court shall exercise its prize jurisdiction in respect to the like persons, matters, things, okay? In other words, what they're saying is if you're a person, they can steal your property, okay? That's exactly what it is, okay? They're pirates is what they are. They're nothing but pirates operating on the high seas of commerce looking for some prize. You read the Trading with the Enemy Act, and it's the same thing. If you read, remember we went and saw the Interpretation Act in Canada, and Canada is defined as the inland waterways and the coastal waterways. Well, gee, and now they're getting prize. It sounds like a bunch of pirates to me, you know. That's exactly what they are, and actually, piracy is a perfectly legitimate enterprise. So, you know, the point is that it's the burden's on you to protect yourself, and the point is that if you know who you are, they're not going to want to talk to you. okay? Because they only have jurisdiction over persons. Are you a person? Do you know who you are?